Question 1. Topic: Conflicts of interest. Former client conflicts in high-stakes environment where multiple challenges arise in corporate litigation. Attorney previously represented Company X in major antitrust lawsuit. Years later, Company X is engaged in contract dispute against Company Y. Attorney is now representing Company Y in the dispute. Although the matters are not directly related, attorney had access to sensitive data of Company X during the antitrust litigation, which could be relevant to the current case. Company X has raised an objection, claiming conflict of interest. What is the most ethical course of action for attorney A? A. Continue representing Company Y as the antitrust case and contract dispute are unrelated. B. Seek Company X's consent after full disclosure of the potential conflict. C. Withdraw from representing Company Y as the prior representation of Company X creates substantial relationship with the new matter. D. Ignore Company X's objections as the conflict applies only if the cases are identical. Answer: C. Withdraw from representing Company Y as the prior representation of Company X creates a substantial relationship with the new matter. Explanation: under Model Rule 1.98 of the American Bar Association about Model Rules of Professional Conduct, a lawyer who has formally represented a client cannot later represent another client in a matter that is substantially related if their interests are materially adverse, unless former client provides informed consent. The substantial relationship test applies when the lawyer has gained confidential information from the former client that is relevant to the new matter. Here, attorney access to Company X's sensitive financial data could provide an unfair advantage in the contract dispute, creating conflict of interest. Option is incorrect because even though the matters are different, confidential information from the prior case could be relevant, triggering the conflict rule. Option B is incorrect because even if Company X consents, the duty of confidentiality under Rule 1.6 remains an issue. Option D is incorrect because the conflict standard does not require the two cases to be identical, only that they be substantially related. Thus, withdrawal is the most ethical and legally sound option. Question 2. Topic: Duties to the court and legal system. Candor to the tribunal during an emergency response where multiple areas are impacted. Attorney B is representing client in civil lawsuit and learns that key witness for the client has provided false testimony in court. The testimony significantly favors the client's case. The witness refuses to correct their statement and the client insists on maintaining the testimony to strengthen their position. Attorney B is aware that exposing the false testimony may weaken the case. What is Attorney B's ethical obligation under the rules of professional conduct? A. Do nothing, as the duty of confidentiality to the client prohibits disclosing the false testimony. B. Privately advise the client and witness to correct the testimony, but take no further action if they refuse. C. Inform the court of the false testimony, even if it harms the client's case. D. Continue presenting the false testimony, as an attorney's duty is to zealously advocate for their client. Answer: C. Inform the court of the false testimony, even if it harms the client's case. Explanation: under about Model Rule 3.3a3, lawyer must not only offer false evidence and must take reasonable remedial measures if they become aware that false evidence has been introduced. If the client or witness refuses to correct the testimony, the lawyer has an overriding duty of candor to the tribunal and must disclose the false statement, even if it negatively impacts the client's case. Option is incorrect because the duty of confidentiality under Rule 1.6 does not override the duty of candor to the tribunal. Option B is incorrect because merely advising the client and witness without further action does not fulfill the lawyer's ethical obligation. Option D is incorrect because lawyer's duty to zealously represent client is limited by the ethical obligation to uphold justice and truth in legal proceedings. Failure to disclose false testimony could result in professional discipline, including suspension or disbarment. Question 3. Topic: Advertising, solicitation, and client development. Prohibited solicitations when implementing new protocols in shared environment. Attorney C is looking to expand their law firm's client base. They obtain list of potential clients who have recently been injured in car accidents and send them targeted letters offering legal representation. The letters contain truthful information about Attorney C's experience handling cases and include disclaimers stating that recipients are under no obligation to respond. However, some recipients complain that they feel pressured to hire Attorney C. Under the above model rules, is this form of solicitation permissible? A. Yes, because the letters contain truthful information and do not mislead potential clients. B. No, because Direct solicitation of potential clients known to need legal services is prohibited unless there is pre-existing relationship. C. Yes, because as long as the recipients have the option to ignore the letter, no ethical violation occurs. D. No, because attorneys are not allowed to advertise their services in any written form. Answer B. No, because direct solicitation of potential clients known to need legal services is prohibited unless there is a pre-existing relationship. Explanation. Under BAM Model Rule 7.38, a lawyer may not solicit professional employment from a prospective client through direct in-person, live telephone, or real-time electronic communication if the lawyer's primary motive is financial gain. Written solicitations, such as letters, omitted under Rule 7.3b only if they are not misleading or coercive. However, targeted solicitation of individuals known to require legal services due to specific events, such as recent car accident, is often considered improper because it can exploit vulnerable clients. Option is incorrect because while the letters may be truthful, they still constitute direct solicitation of individuals who may be in distress. Option C is incorrect because the presence of disclaimer does not eliminate the potential for coercion. Option D is incorrect because lawyers may advertise through written and digital media provided they comply with ethical guidelines. Thus, Attorney C's conduct likely violates professional responsibility rules, making the solicitation unethical. Question 4. Topic: Conflicts of interest. Former client conflicts. While investigating inconsistencies across various units in Malta National Corporation, and Attorney Jane is approached by new client Zeiss Tech Limited, which seeks legal representation in trade secret misappropriation lawsuit against ABC Solutions Inc. Jane previously represented ABC Solutions Inc. in complex intellectual property dispute 3 years ago. Although the prior case was unrelated to trade secret issues, Jane had access to ACT's internal risk management strategies and confidential research documents. Zeiss Tech Limited insists that there is no real conflict because the cases are unrelated and Jane's prior work focused on copyright law rather than trade secrets. However, ABC Solutions Inc. files motion to disqualify Jane, arguing that her prior representation conflict under legal ethics rules. Under the ABAM Model Rules of Professional Conduct, which of the following best describes Jane's ethical obligations in this scenario? A. Jane may represent Zeiss Tech Limited if she obtains written informed consent from ABC Solutions Inc. B. Jane is automatically disqualified from representing Zeiss Tech Limited due to her prior involvement with ABC Solutions Inc. C. Jane may proceed with representation because the prior matter was unrelated and no actual conflict exists. D. Jane must seek court approval before representing Zeiss Tech Limited in or determine whether an ethical violation has occurred. Answer A. Jane may represent Zeiss Tech Limited if she obtains written informed consent from ABC Solutions Inc. Explanation. Under ABAM Model Rule 1.98, a lawyer who has formally represented a client cannot represent another client in a substantially related matter in which that client's interests are materially adverse to the former client unless the former client gives informed consent in writing. Even though Jane's prior case involved copyright law rather than trade secrets, her access to confidential information relevant to ABC Solutions Inc.'s risk management could pose risk of material adversity. Option correct. This reflects the appropriate ethical standard. Jane can represent Zeiss Tech Limited only if ABC Solutions Inc. gives informed consent in writing. Option B, incorrect. Disqualification is not automatic unless the matters are substantially related and there is significant risk of Jane using confidential information. Option C, incorrect. Even though the matters are unrelated, Jane had access to potentially relevant confidential information, which raises conflict of interest. Option D, incorrect. Court approval is not required unless the conflict is contested in litigation. The duty is on Jane to ensure compliance with ethical rules. Question 5. Topic: Duties to the court. Candor to the tribunal during high-stakes trial. Attorney Michael represents corporate client accused of fraud. While preparing key witness, he discovers that the witness intends to testify falsely about critical financial statements. Michael knows that if the witness testifies as planned, it could materially mislead the court in favor of his client. However, the client insists that Michael allow the witness to and argues that it is the witness's own statement, not Michael's, that would be false. Under BAM Model Rule 3.3, how should Michael handle this situation? A. Allow the witness to testify as planned, since Michael himself is not making the false statement. B. Disclose the witness's intent to the court immediately, even if it harms his client. C. Attempt to persuade the witness to correct their statement, and if they refuse, take remedial measures, including disclosure if necessary. D. Withdraw from the case without informing the court, as continued representation could create an ethical dilemma. Answer: C. Attempt to persuade the witness to correct their statement, and if they refuse, take remedial measures, including disclosure if necessary. Explanation: under About Model Rule 3.3a3, an attorney must not only offer evidence that the lawyer knows to be false. If a lawyer later discovers that a witness intends to provide false testimony, they must take reasonable remedial measures. Option C, correct. Michael must first attempt to persuade the witness to correct their statement. If the witness refuses, he must take reasonable remedial measures, including notifying the court if necessary. Optional incorrect. Even though Michael is not making the statement himself, allowing false testimony violates his duty of candor to the tribunal. Option B, incorrect. While disclosure may be necessary, Michael must first try to prevent the false testimony before taking that step. Option D, incorrect. Withdrawal alone does not satisfy Michael's ethical obligations, as it does not prevent the false testimony from being introduced. Question 6. Topic: Ethics in technology and law practice. Cybersecurity and data privacy obligations. When implementing new protocols in shared environment, mid-sized law firm decides to migrate all client files to cloud-based document management system. The firm's IT consultant assures them that the new system provides adequate security, but one of the partners raises concerns about potential cybersecurity risks. The firm, highly sensitive corporate transactions and data breach could expose confidential client information. Under About Model Rule 1.6, C. What is the firm's ethical responsibility regarding client data protection? A. The firm must ensure the absolute security of client data, eliminating all potential cybersecurity threats. B. The firm is required to take reasonable measures to prevent unauthorized access to confidential client information. C. The firm has no ethical obligation if the consultant has already approved the cloud system. D. The firm may proceed without additional precautions because cloud storage is widely used in the legal industry. Answer: B. The firm is required to take reasonable measures to prevent unauthorized access to confidential client information. Explanation: under About Model Rule 1.6, C. Lawyers must take reasonable efforts to prevent inadvertent or unauthorized disclosure of or unauthorized access to client information. This does not require absolute security, but lawyers must use due diligence in selecting and monitoring technology providers. Option B, correct. The firm must ensure it takes reasonable measures such as encrypting files, implementing access controls, and vetting third-party vendors for security compliance. Option was incorrect. Absolute security is impossible, and the standard is one of reasonableness, not perfection. Option C, incorrect. The firm cannot delegate its ethical obligations entirely to an IT consultant without independent due diligence. Option D, incorrect. The use of cloud storage does not automatically satisfy ethical requirements. Security measures must still be evaluated. Question 7. Topic: Legal ethics. Attorney-client privilege and confidentiality. While evaluating the obligations of an attorney handling sensitive corporate matters, lawyer Sarah represents a publicly traded company that is under investigation by the SEC for potential insider trading violations. During private meeting with the company's CFO, he admits that he knowingly provided confidential earnings data to close friend who then used it to make profitable stock trades. However, the CFO insists that the lawyer must keep this information confidential under attorney-client privilege. Under About Model Rule 1.6, confidentiality of information, which of the following best describes Sarah's ethical obligations in this scenario? A. Sarah must maintain strict confidentiality and cannot disclose the CFO's statement to anyone. B. Sarah may disclose the information if she reasonably believes it is necessary to prevent substantial harm or financial fraud. C. Sarah must immediately report the CFO's admission to the SEC to avoid liability for failing to disclose fraudulent conduct. D. Sarah can disclose the information only if the CFO gives explicit written consent. Answer: B. Sarah may disclose the information if she reasonably believes it is necessary to prevent substantial harm or financial fraud. Explanation: Under About Model Rule 1.6b2(3), an attorney may disclose confidential client information if the lawyer reasonably believes disclosure is necessary to prevent the client from committing a crime or fraud that is likely to result in substantial financial harm. Option incorrect. Confidentiality is a general rule, but it is not absolute. There are exceptions for preventing financial fraud. Option B correct. Since the CFO's actions involve potential ongoing fraud and insider trading violations, SERA is permitted, but not required, to disclose the information to prevent harm. Option C incorrect. While disclosure is allowed, it is not mandatory unless required by law or court order. Option D incorrect. Attorney-client privilege does not override exceptions related to preventing fraud or harm. Question 8. Topic: Conflict of interest. Government lawyers move into private practice while analyzing the transition of government attorneys to private practice. Former Department of Justice Dutch attorney Alex recently joined private law firm. During his time at the Dutch, Alex worked on major antitrust investigation against multinational corporation Megacorp. Shortly after joining the law firm, he is assigned to represent client lawsuit against Megacorp on an unrelated matter. However, Megacorp files motion to disqualify Alex, arguing that his prior work at the Dutch creates conflict of interest. Under About Model Rule 1.11, special conflicts of interest for former and current government officers and employees, which of the following best describes Alex's ethical obligations? A. Alex is automatically disqualified from any case involving Megacorp even if the matters are unrelated. B. Alex may represent the new client if he did not personally and substantially participate in the prior Dodge investigation of Megacorp. C. Alex may represent the client only if Megacorp provides written informed consent. D. Alex may proceed with representation as long as his law firm screens him from any discussion related to Megacorp. Answer: B. Alex may represent the new client if he did not personally and substantially participate in the prior Dodge investigation of Megacorp. Explanation: under About Model Rule 1.11, a former government lawyer cannot represent a private client if the lawyer personally and substantially participated in the same matter while working for the government. However, if Alex's prior work did not involve substantial participation, he is automatically disqualified. Option incorrect. There is no automatic disqualification unless Alex's prior role involved direct participation in the matter. Option B correct. If Alex's involvement in the Dodge investigation was minimal, he is not barred from representing the new client. Option C incorrect. Government attorneys do not need the former client's Megacorp's consent unless there is direct ethical conflict. Option D incorrect. Screening alone does not resolve the issue if Alex personally and substantially participated in the prior investigation. Question 9. Topic: Attorney misconduct. Unauthorized practice of law. While reviewing ethical concerns regarding legal services across state lines, an attorney licensed in California, Mark, is asked to represent client in real estate transaction in Texas, where he is not licensed to practice. Mark does not plan to relocate but intends to advise the client remotely and negotiate the contract. The client is aware that Mark is Texas licensed attorney but insists on his representation due to Mark's real estate expertise. Under About Model Rule 5.5, unauthorized practice of law, a multi-jurisdictional practice, is Mark permitted to proceed with representation? A. Yes, because the client knowingly consented to Mark's representation. B. No, because Mark is not licensed in Texas and is engaging in unauthorized practice. C. Yes, but only if Mark associates with Texas licensed attorney who actively participates in the representation. D. No, unless Mark limits his role to general legal advice rather than direct representation in Texas real estate law. Answer: C. Yes, but only if Mark associates with a Texas licensed attorney who actively participates in the representation. Explanation: under About Model Rule 5.5, C. An attorney licensed in one jurisdiction may provide legal services in another state only if they associate with a licensed attorney from that state who actively participates in the case. Option is incorrect. Client consent alone does not permit unauthorized legal practice. Option B incorrect. Mark may practice in Texas, but only under specific conditions. Option C correct. Associating with a Texas licensed attorney ensures compliance with ethics rules. Option D incorrect. Limiting services to general advice does not fully resolve unauthorized practice concerns. Question 10. Topic: Duty to avoid frivolous claims. Rule 11 sanctions. While considering the ethical implications of filing meritless lawsuits, an attorney, Lisa, is representing client who demands that she file lawsuit against former business partner for emotional distress caused by business dispute. However, after reviewing the evidence, Lisa determines that the lawsuit lacks any legal basis and would likely be dismissed. The client insists that file the claim anyway, stating, "Let the court decide." Under Federal Rule of Civil Procedure 11, what are Lisa's ethical obligations in this situation? A. Lisa must proceed with the lawsuit since she is bound by the client's instructions. B. Lisa should refuse to file the lawsuit because it lacks legal basis and could result in Rule 11 sanctions. C. Lisa should file the lawsuit but argue for broad interpretation of the law to justify the claim. D. Lisa may file the lawsuit only if she includes disclaimer that it is based solely on the client's assertions. Answer. B. Lisa should refuse to file the lawsuit because it lacks a legal basis and could result in Rule 11 sanctions. Explanation. Under Rule 11b, an attorney must ensure that all legal claims they present are warranted by law and supported by evidence. Filing a frivolous claim could result in sanctions. Option was incorrect. An attorney is not obligated to file a meritless lawsuit. Option B, correct. Filing the lawsuit violates ethical rules and could lead to sanctions. Option C, incorrect. Lawyers cannot justify frivolous claims with overly broad legal interpretations. Option D, incorrect. A disclaimer does not eliminate Rule 11 liability. Question 11. Topic: Attorney-client privilege. Crime-fraud exception. While analyzing the ethical obligations of an attorney in criminal defense cases, criminal defense lawyer David is representing client accused of money laundering. During confidential meeting, the client reveals that he is still actively engaged in illegal financial transactions and seeks David's advice on how to move of the money without raising suspicion. David reminds client that he cannot assist with illegal conduct, but the client insists that the conversation is protected by attorney-client privilege. Under the crime-fraud exception to attorney-client privilege, which of the following best describes David's ethical obligations? A. David must maintain confidentiality because attorney-client privilege is absolute. B. David may disclose the conversation because the client is seeking advice to facilitate ongoing criminal activity. C. David should withdraw from representation but cannot disclose the information. D. David must report the client's statements to law enforcement immediately. Answer. B. David may disclose the conversation because the client is seeking advice to facilitate ongoing criminal activity. Explanation. The crime-fraud exception states that attorney-client privilege does not protect communications made for the purpose of committing or covering up a crime. BAM Model Rule 1.6b2 allows attorneys to reveal information if necessary to prevent a crime. Optionals, incorrect. Attorney-client privilege is not absolute. It does not cover requests for assistance in future crimes. Option B, correct. Since the client is actively engaged in crime and seeking legal advice to further, David may disclose the conversation. Option C, incorrect. Withdrawal alone does not resolve the ethical issue when the crime-fraud exception applies. Option D, incorrect. Disclosure is permitted but not mandatory unless required by law. Question 12. Topic: Judicial ethics. Ex parte communications. While evaluating the ethical boundaries for judicial conduct, trial Judge Roberts is presiding over a high-profile criminal case. During recess, the prosecutor approaches him in private and expresses concerns about the defense counsel's tactics. The prosecutor does not discuss evidence but argues that the defense strategy is misleading the jury. Under BAM Model Code of Judicial Conduct Rule 2.9, ex parte communications, how should Judge Roberts respond? A. The judge may listen to the prosecutor but must disclose the conversation to the defense. B. The judge must refuse to engage in the discussion and remind the prosecutor that ex parte communications are prohibited. C. The judge may discuss procedural matters with the prosecutor as long as he does not provide an advantage. D. The judge should consider the prosecutor's concerns privately and use discretion in addressing them. Answer. B. The judge must refuse to engage in the discussion and remind the prosecutor that ex parte communications are prohibited. Explanation. Under Rule 2.9a, a judge must not initiate or consider ex parte one-sided communications about a pending case unless an exception applies. E.g. administrative matters or emergencies. Option was incorrect. Disclosure does not cure the violation of an improper communication. Option B, correct. The judge must not engage in any unauthorized discussion about the case. Option C, incorrect. Judges may only discuss strictly procedural matters in limited circumstances. Option D incorrect. A judge cannot privately consider one side's argument without the other present. Question 13. Topic: Legal malpractice. Duty of competence. While considering the responsibilities of an attorney in handling client matters, an attorney, Rebecca, agrees to represent client in an intellectual property dispute. Despite having no prior experience in patent law, she does minimal research and misses crucial deadline, leading to the client losing their patent rights. The client sues for malpractice. Under Bauer Model Rule 1.1, competence. Which of the following best describes Rebecca's ethical violation? A. She violated her duty of competence by taking on case in an area where she lacked necessary expertise. B. She committed no violation because attorneys are not required to specialize in specific fields. C. She was competent as long as she attempted to research the case. D. She is only liable if the client can prove intentional misconduct. Answer A. She violated her duty of competence by taking on a case in an area where she lacked necessary expertise. The explanation. Under Rule 1.1, attorneys must possess the necessary legal knowledge and skill before representing clients in specialized areas. Option was correct. Taking on a case without proper preparation or expertise is a violation of professional competence. Option B incorrect. While lawyers don't have to specialize, they must be competent in the matters they handle. Option C incorrect. Minimal research does not compensate for lack of specialized knowledge in patent law. Option D incorrect. Legal malpractice does not require intentional misconduct. Negligence is enough. Question 14. Topic: Professional responsibility. Conflicts of interest in law firms. While considering the ethical responsibilities of law firms in managing conflicts of interest, senior attorney at large law firm Lisa is representing corporate client in contract dispute. Unbeknownst to her, another attorney in the firm is simultaneously representing the opposing party in an unrelated matter. Under Bauer Model Rule 1.10, imputation of conflicts of interest. What must the law firm do to address this situation? A. The firm must withdraw from representing both clients unless informed consent is obtained. B. The firm could continue both representations as long as different attorneys handle each case. C. The firm can proceed with representation only if it implements conflict screening mechanism. D. The firm is not required to take action unless one of the client's objects. Answer A. The firm must withdraw from representing both clients unless informed consent is obtained. Explanation. Under Rule 1.10a, a conflict affecting one attorney in a firm extends to all attorneys unless it is waived with informed consent. Option was all correct. The law firm cannot represent both parties unless both clients give informed consent. Option B incorrect. Assigning different attorneys does not resolve the conflict unless consent is obtained. Option C incorrect. Screening mechanisms do not apply in concurrent client conflicts. Option D incorrect. Ethical duties apply regardless of whether client's object. Question 15. Topic: Corporate governance. Fiduciary duties of directors and officers. While examining the fiduciary responsibilities of corporate executive CEO Mark learns of an upcoming merger that will significantly increase the value of his company's stock. Before this information becomes public, he buys large number of shares for himself and tells his close friend to do the same. Under the fiduciary duties of loyalty and care, which of the following best describes Mark's actions? A. Mark breached his duty of loyalty by using confidential information for personal gain. B. Mark acted legally because he did not disclose the information to the public. C. Mark did not violate any fiduciary duties because corporate executives are allowed to invest in their own companies. D. Mark's actions are only unethical if the merger does not happen. Answer A. Mark breached his duty of loyalty by using confidential information for personal gain. Explanation. Corporate executives owe a fiduciary duty to the company and its shareholders, including the duty of loyalty, acting in the company's best interest, and the duty of care, making informed decisions. Obstacles are correct. Mark used confidential, non-public information for personal gain, violating his duty of loyalty. Option B incorrect. Failing to disclose information to the public does not excuse insider trading. Option C incorrect. While executives can own stock, they cannot trade on non-public information. Option D incorrect. The violation occurs regardless of the outcome of the merger. Question 16. Topic: Legal ethics, attorney-client confidentiality and fraudulent conduct. While assessing an attorney's obligations when confronted with potential fraud, an attorney, Sarah, discovers that her client has forged important documents in an ongoing litigation case. Sarah did not assist in the fraud, but she now realizes that the false documents have been submitted to the court. Under BAM Model Rule 3.3, candor toward the tribunal. How should Sarah respond? A. Sarah must inform the court about the fraudulent documents, even if it harms her client's case. B. Sarah should remain silent because of attorney-client confidentiality. C. Sarah must attempt to convince the client to correct the fraud but cannot disclose it without permission. D. Sarah should withdraw from the case but does not need to inform the court. Answer A. Sarah must inform the court about the fraudulent documents even if it harms her client's case. Explanation. Under Rule 3.3, attorneys cannot knowingly present false evidence and must correct fraud on the court. Option correct. Sarah must disclose the fraud if the client refuses to correct it. Option B incorrect. Attorney-client privilege does not apply when fraud has been committed on the court. Option C incorrect. Convincing the client to correct the fraud is important, but disclosure is still required if the client refuses. Option D incorrect. Withdrawing does not resolve the issue. The attorney has duty to inform the court. Question 17. Topic: Securities law, insider trading and misappropriation theory. While analyzing the legal consequences of insider trading, corporate attorney Daniel learns confidentially that his client, biotech company, is about to announce breakthrough drug that will increase stock value significantly. Daniel tells his brother to buy stock before the announcement. Under the misappropriation theory of insider trading, which of the following is true? A. Daniel violated insider trading laws by misusing non-public information for personal gain. B. Daniel did not violate any law because he personally did not buy stock. C. Daniel's brother is solely responsible for any legal violations. D. Insider trading only applies to executives, not attorneys. Answer A. Daniel violated insider trading laws by misusing non-public information for personal gain. Explanation. Under the misappropriation theory, individuals who use confidential information in breach of a duty. G. Attorneys commit insider trading. Options are correct. Daniel used confidential information improperly, violating securities laws. Option B incorrect. Tipping someone else to trade is still illegal insider trading. Option C incorrect. Both Daniel and his brother can be held liable. Option D incorrect. Insider trading laws apply to anyone who improperly uses non-public information. Question 18. Topic: Employment law, workplace harassment and employer liability. While considering an employer's legal obligations regarding workplace harassment, an employee, Lisa, repeatedly reports that her manager is sexually harassing her. The company fails to investigate or take action, and Lisa eventually resigns due to hostile work environment. Under Title Roman of the Civil Rights Act, what liability does the company face? A. The company is liable for allowing hostile work environment and failing to take corrective action. B. The company is not responsible because Lisa chose to resign. C. The manager is solely liable, not the company. D. The company is only liable if Lisa was fired, not if she resigned voluntarily. Answer A. The company is liable for allowing a hostile work environment and failing to take corrective action. Explanation. Under Title Roman, employers must prevent and address workplace harassment. Optional correct. The company failed to investigate and respond, making it liable. Option B incorrect. Constructive dismissal occurs when an employee is forced to resign due to harassment. Option C incorrect. Employers are responsible for supervisors' misconduct. Option D incorrect. Liability applies whether the employee quits or is fired. Question 19. Topic: Contracts, unilateral and bilateral mistakes in contract formation. While exploring the impact of mistakes in contract law, buyer agrees to purchase rare painting from seller for $50,000, believing it to be an original. The seller also mistakenly believes it is original, but both later learn it is reproduction worth only $5,000. Under contract law principles, what happens to the agreement? A. The contract is voidable because both parties were mistaken about fundamental fact. B. The buyer must still pay because contracts are binding. C. The seller can demand full payment since the contract was agreed upon. D. The contract remains valid, but the seller must compensate the buyer for the mistake. Answer A. The contract is voidable because both parties were mistaken about a fundamental fact. Explanation. A mutual mistake about a key fact can make a contract voidable. Option was correct. Since both parties misunderstood the value and authenticity, the contract can be rescinded. Option B incorrect. Contracts can be voided for mutual mistake. Option C incorrect. The seller cannot enforce a contract based on mistaken facts. Option D incorrect. The contract must be rescinded, not merely adjusted. Question 20. Topic: Tort law, negligence and duty of care. While considering the legal implications of negligence in personal injury cases, grocery store owner Alex is aware that freezer in his store has been leaking water onto the floor for several days. Despite multiple complaints from employees, Alex does not fix the issue or place any warning signs. One day, customer Lisa slips on the water, falls, and suffers severe back injury. Under the principles of premises liability and negligence, which of the following is most accurate? A. Alex is liable because he had duty to maintain safe conditions and failed to act. B. Alex is not liable because Lisa should have been more careful while walking. C. Lisa cannot sue because she voluntarily entered the store. D. Alex is only liable if Lisa can prove he intentionally left the hazard unfixed. Answer A. Alex is liable because he had the duty to maintain safe conditions and failed to act. Explanation: negligence in premises liability cases requires proving that the store owner owed a duty, breached it, and that the breach caused injury. Option was correct. Alex knew of the hazard but did not fix it or warn customers, violating his duty. Option B incorrect. While customers must be aware, the store owner must prevent foreseeable risks. Option C incorrect. Voluntarily entering the store does not mean Lisa assumed the risk of unsafe conditions. Option D incorrect. Liability does not require intent, only negligence. Question 21. Topic: Business law. Contractual breach and remedies. While assessing the legal consequences of contractual breach, company GreenTech contracts with supplier Blue Steel to deliver custom steel parts by June 1st for an important project. However, Blue Steel fails to deliver the parts on time, causing GreenTech to miss government contract worth $500,000. What legal remedy is GreenTech most likely to seek? A. Expectation damages to recover lost profits. B. Specific performance to force Blue Steel to deliver the parts. C. Nominal damages since the delay did not cause direct loss. D. No remedy because delivery dates in contracts are not strictly enforced. Answer A. Expectation damages to recover lost profits. Explanation: when a breach of contract causes financial loss, the injured party is entitled to damages. Option E was correct. Expectation damages compensate for lost profits from the government contract. Option B incorrect. Specific performance is used when money cannot fix the breach, which is not the case here. Option C incorrect. The damages are not nominal. GreenTech suffered a major financial loss. Option D incorrect. Contract deadlines can be enforced if they impact business performance. Question 22. Topic: Intellectual property. Trademark infringement. While analyzing the legal implications of trademark infringement, small business Tasty Bites uses logo and branding very similar to well-known fast food chain. The larger company sues for trademark infringement, arguing that customers might confuse the two brands. Which factor is most important in determining infringement? A. Whether consumers are likely to be confused. B. Whether Tasty Bites intentionally copied the logo. C. Whether the companies sell the exact same products. D. Whether Tasty Bites is making less revenue than the larger company. Answer A. Whether consumers are likely to be confused. Explanation: trademark infringement focuses on likelihood of confusion among consumers. Opticals are correct. If customers mistakenly associate Tasty Bites with the larger brand, it is infringement. Option B incorrect. Intent is not required, but even accidental confusion is illegal. Option C incorrect. The products do not need to be identical, just similar enough to confuse consumers. Option D incorrect. Revenue is not factor in determining infringement. Question 23. Topic: Employment law. Wrongful termination and retaliation. While examining employer responsibilities in wrongful termination cases, an employee Jake reports safety violations in his company shortly after his employer fires him without explanation. Under whistleblower protection laws, which of the following is true? A. Jake can sue for retaliation because he engaged in protected activity. B. Jake cannot sue because employment is at will. C. The employer can fire Jake as long as no specific reason is given. D. Jake is only protected if he had already worked for the company for at least 5 years. Answer A. Jake can sue for retaliation because he engaged in protected activity. Explanation: whistleblower laws protect employees who report illegal or unsafe workplace conditions. Option was correct. Jake's firing is likely retaliation, which is illegal. Option B, incorrect. At-will employment does not allow retaliation for whistleblowing. Option C, incorrect. Lack of an explanation does not shield employers from retaliation claims. Option D, incorrect. Whistleblower laws apply regardless of tenure. Question 24. Topic: Securities law. Fraudulent misrepresentation in investments. While evaluating the legal consequences of fraudulent investment practices, financial advisor Laura convinces clients to invest in fake real estate fund by lying about guaranteed profits. Which securities law has Laura most likely violated? A. The Securities Exchange Act of 1934. B. The Fair Labor Standards Act. C. The Uniform Commercial Code. D. The Sherman Antitrust Act. Answer A. The Securities Exchange Act of 1934. Explanation: the Securities Exchange Act of 1934 prohibits fraudulent investment schemes. Optionals are correct. Misrepresenting investments violates securities fraud laws. Option B, incorrect. The FLSA relates to wage and hour laws, not investments. Option C, incorrect. The Act governs commercial transactions, not securities fraud. Option D, incorrect. The Sherman Act regulates monopolies, not investment fraud. Question 25. Topic: Real estate law. Landlord-tenant disputes and eviction procedures. While assessing legal protections for tenants facing eviction, landlord evicts tenant without notice despite the tenant having paid rent on time. What legal protection does the tenant have? A. The tenant can sue for wrongful eviction. B. The landlord can evict for any reason. C. The tenant has no rights if the lease has expired. D. The tenant must leave immediately without legal recourse. Answer A. The tenant can sue for wrongful eviction. Explanation: most states require proper notice and valid reasons for eviction. Optionals are correct. Evicting without notice violates tenant rights. Option B, incorrect. Landlords must follow eviction laws. Option C, incorrect. Even after lease expiration, landlords must provide notice. Option D, incorrect. Tenants can challenge illegal evictions in court. Question 26. Topic: Consumer protection. Unfair trade practices. While analyzing the effects of deceptive advertising on consumer rights, clothing company claims its product is 100% organic, but recent investigation reveals that the fabric is only 50% organic. Consumers purchase the clothing based on the false claim and experience disappointment and frustration. Which law or regulation is likely to be violated? The company's actions. A. The Federal Trade Commission Act (FTC) Act. B. The Sherman Antitrust Act. C. The Fair Credit Reporting Act. D. The Consumer Product Safety Act. Answer A. The Federal Trade Commission Act (FTC) Act. Explanation: deceptive advertising practices fall under the FTC Act, which protects consumers from false or misleading claims. Option is correct. The FTC Act prohibits unfair or deceptive advertising and is the appropriate law for this situation. Option B, incorrect. The Sherman Antitrust Act regulates monopolistic practices and does not apply to deceptive advertising. Option C, incorrect. The Fair Credit Reporting Act governs credit reporting, not advertising claims. Option D, incorrect. The Consumer Product Safety Act regulates product safety, but this case involves deceptive advertising, not safety. Question 27. Topic: Tax law. Corporate tax avoidance. While evaluating strategies used by corporations to minimize tax liabilities, multinational company uses complex transfer pricing arrangements between its subsidiaries in different countries. These arrangements are designed to allocate profits to countries with lower tax rates. Where's the primary issue with this practice? A. It is a legitimate method of tax planning. B. It may be considered tax avoidance and subject to scrutiny. C. It violates international trade laws. D. It is illegal under domestic taxation laws. Answer B. It may be considered tax avoidance and subject to scrutiny. Explanation: transfer pricing is legal when done properly, but it can be scrutinized if it is seen as an attempt to avoid paying taxes in higher tax countries. Optional incorrect. While tax planning is legal, transfer pricing must follow strict guidelines and cannot be used to avoid taxes. Option B, correct. This strategy may be challenged by tax authorities as tax avoidance. Option C, incorrect. Transfer pricing itself does not violate trade laws, but improper practices could lead to tax violations. Option D, incorrect. The practice is not inherently illegal, but improper application can lead to legal consequences. Question 28. Topic: Environmental law. compliance with regulations while assessing the impact of environmental regulations on industrial operations. Factory Ecotech is discharging toxic chemicals into nearby river, violating state and federal water pollution laws. Local community depends on the river for drinking water. What legal action can be taken against Ecotech? A. The company can be fined and required to clean up the pollution. B. Ecotech is not liable since the pollution is not directly harming people. C. The company can continue operating without any consequence if it fixes the issue within 90 days. D. Ecotech can be sued for damages only if individuals in the community are harmed. Answer A. The company can be fined and required to clean up the pollution. Explanation. Under both state and federal environmental laws, pollution violations can lead to fines and mandatory remediation efforts. Options are correct. Ecotech can be penalized and forced to clean up the pollution under environmental regulations like the Clean Water Act. Option B, incorrect. The company is still liable for the pollution even if no immediate harm to people is evident. Option C, incorrect. The company is not given 90 days to fix the issue without penalties. Immediate action is required. Option D, incorrect. The company can face legal actions before harm occurs as preventive measures can be ordered. Question 29. Topic: Family law. Child custody. While analyzing child custody disputes, parents Sarah and Mark are going through divorce. They both seek primary custody of their child, Ethan, who is 7 years old. Sarah argues that Mark has a history of substance abuse, while Mark claims that Sarah has been neglectful in her duties as parent. In determining best interests of the child, which factor is most important for the court to consider? A. The parent's ability to provide stable environment. B. The parent's financial status. C. The parent's work schedule. D. The child's preference, as Ethan is 7 years old. Answer A. The parent's ability to provide a stable environment. Explanation. The best interests of the child standard evaluates stability, safety, and the ability of each parent to provide for the child's emotional and physical needs. Option was correct. The court will prioritize the child's stability, which includes environmental consistency, safe living conditions, and the capacity to meet basic needs. Option B, incorrect. Financial status is considered, but it is not the primary factor in custody decisions. Option C, incorrect. A parent's work schedule is relevant, but it does not outweigh other factors like safety or emotional support. Option D, incorrect. At 7 years old, Ethan's preference may be considered, but is not determinative. The child's age limits the weight of this factor. Question 30. Topic: Bankruptcy law. Chapter 7 verses. Chapter 13. While considering bankruptcy options for individuals in financial distress, an individual, John, owes significant amounts of credit card debt and medical bills. He seeks legal advice on whether to file for Chapter 7 or Chapter 13 bankruptcy. What is the primary difference between these two forms of bankruptcy? A. Chapter 7 allows for debt discharge, while Chapter 13 requires payment plan. B. Chapter 7 requires repayment plan, while Chapter 13 allows for debt discharge. C. Chapter 7 allows individuals to keep all their assets, while Chapter 13 requires them to liquidate assets. D. Chapter 7 is available only to individuals with substantial income, while Chapter 13 is for those with limited income. Answer A. Chapter 7 allows for debt discharge, while Chapter 13 requires a payment plan. Explanation. Chapter 7 bankruptcy is designed for debt discharge, while Chapter 13 allows for restructured payment plans. Options are correct. Chapter 7 is a liquidation process where unsecured debts are discharged after the sale of non-exempt assets. Chapter 13 involves a repayment plan over several years. Option B, incorrect. This description reverses the key characteristics of each chapter. Option C, incorrect. In Chapter 7, some assets may be liquidated. In Chapter 13, the debtor typically keeps all assets but follows a repayment plan. Option D, incorrect. Chapter 7 is available for individuals with limited income. Chapter 13 requires income sufficient to adhere to a repayment plan.